Okay, good afternoon. I'm Mike Saporito. I'm the CLE coordinator here at the Social Law Library. Welcome to our Undue Influence program. It's great to have so many of you with us here today. A few things before we begin today's program. We ask that you use the Q&A feature in Zoom and not the chat feature for questions that you may want to ask the panel. They and I will be monitoring the question and answer box. I'll try to keep my eye on the chat, but we're not going to be focused on that. Near the end of the program, I'll put a survey link in the chat box that you can use. We'd appreciate hearing back from you with any feedback. And we are recording this program, and I will send the video link out to anybody who registered for today's program. Usually get that out within 24 hours. Today, I want to introduce our panelists. First, retired probate and family court judge Anthony Nesi, who is currently engaged in conciliation of domestic relations, estate and trust cases. And we also have trust and estate litigation, guardianship, and conservatorship attorney, Darian Butcher from Butcher Law, LLC. Welcome. And we're happy to have clinical neuropsychologist from Northboro, Massachusetts, Dr. Elizabeth Nasser. And last and most certainly not least, our moderator today is estate planning, trust, estate, and gift taxation, mass health and probate and elder law attorney, Brian Barreira from the law offices of Brian Barreira. Welcome to all of you, and welcome, Brian.
Okay, I have to just disagree with you and least. I am least. And I'm just going to take credit for the three panelists and all their brilliance. But thank you, everybody, for joining. We're going to be talking about undue influence today. What is it? I can't define it. So that's our first question for the panel. What is it? What is undue influence? Influence, there's influence, then there's undue influence. What's the difference? Darian, why don't you get started?
Sure. I think Judge Nesi will agree with me. You know it when you see it. It's one of those kind of
Exactly. That's perfect.
I mean, technically, what are we looking for? We're looking for an unnatural disposition that's been made by a person that's susceptible to undue influence to the advantage of someone with an opportunity to exercise undue influence, and who in fact has used that opportunity to procure the contested disposition through improper means. So those are basically the elements of our claim, but we have to drill down, right? And so when we're talking about what's undue, I was sharing with my panelists before we got started that there's some really sexy language that I always like to quote when I can. It comes from Neil V. Brackett. And it's whatever destroys free agency and constrains the person whose act is under review to do that which is contrary to his own untrammeled desire. It may be caused by physical force, by duress, by threats, by inopportunity. It may arise from persistent and unrelaxing efforts in the establishment or maintenance of conditions intolerable to the particular individual. It may result from more subtle conduct, designed to create an irresistible ascendancy by imperceptible means. It may be exerted either by deceptive devices or by material compulsion without actual fraud. It's any species of coercion, whether physical, mental, or moral, which subverts the sound judgment and genuine desire of the individual. It's enough to constitute undue influence. And I feel like that captures it.
That's all of it. That really is. I couldn't add anything to it other than you're right. You know it when you see it. And even then, it requires a good hard look, because things that might on the surface look like undue influence, when you do drill down, aren't necessarily there. I have to say the vast majority of undue influence cases that I've seen during my time on the bench, and most certainly now that I do a number of them as part of my conciliation practice, really have a hard time crossing that threshold. The majority of them, ultimately, the majority of claims, I think, over the course of time were either dismissed by the court or result in a settlement when I've gotten them in my conciliation practice. It's not easy to prove, not easy to prove at all.
And I'll say in the cases that I'm involved in, typically after the claim of undue influence has been made, although it's not easy to prove when you get to court, like if you've had experience with them, they can be very upsetting because you're seeing a vulnerable person, in my practice, a person who's, had a progressive dementia or is dealing with other mental health issues. And from the outside, you can see how a path was laid for another individual to exert their influence over them. But again, like it can be hard to prove, even in cases where I think that that it's happened and you can see how vulnerable that person was.
One of the things that I'm hearing from both of you is that it has to do with the nature of the evidence that you have to bring forward and the fact that it's, mostly circumstantial evidence. And I would be interested in hearing from both of you your perspective on what evidence is most compelling, given that it's not usually going to be direct. Someone saying, oh yeah, I went over there every day and I said, if you don't sign these papers, I'm going to pull all your toenails out, or whatever it is that happens, right? Like what are the things that you've seen in your experiences that have been sort of compelling circumstantial evidence of undue influence?
Liz, you want to go first?
Yeah, I mean, there's a couple of cases that come to mind. One where, often this happens when someone is maybe at the beginning stages of a dementia, so that they are able to form new relationships and can maybe form new memories. So there's a piece of isolation where other individuals who had been consistently involved in an individual's life are removed. And that's either because they live out of state and so they were only communicating by telephone, or physically, someone has moved the individual somewhere else or is just denying access. And then gradually starts either trying to damage that pre-existing relationship that was in fact a good supportive relationship. And because an individual has some type of dementia or is maybe a little bit paranoid and delusional, can kind of feed into that thinking, my son is just after my money, and that is why he's coming to see me. And I've seen cases where it's a caregiver. I've seen cases where it's a dysfunctional family, where siblings are battling against each other. A recent case, a gentleman made changes to his will while he was in the hospital because he believed that his son was after his property, and the daughter was trying to make him change the will, saying that the daughter is after his property. And there were medical records that showed like how distressed he was, that thinking if he didn't sign this document that the state was going to take all of his property. And the daughters were kind of drilling that, even though he already had an estate plan. He was then compelled, because the son was not given access. The healthcare proxy was changed, so he couldn't come into the hospital to see his father. And the daughters made these changes and were kind of repeatedly telling him and scaring him to make these changes. So that was a case that was pretty compelling, and he's being given false information that he's then repeating because the state was not going to be taking his money, and then made these changes to the will based on what the daughters were telling him, without having any input from the son, who was then cut out of the estate plan altogether.
I think the fact of the isolation is, and when I say isolation, keeping them from their usual contacts is very often one of those red flags that I hear. But the other, and give weight to, but the other thing is look at the dispositions, because things that might appear okay on their face can sometimes be unnatural dispositions, given the history that the people have had, and so you have to look closely. I think the ones that jump out at me the most is when the caregivers end up with the majority, if not all of the estate. That's the simplest and most common one that I see occurring. That's really that really makes your ears perk up. Though I think within families is probably much more common, as Liz talks about, and the But on the other hand, very often I see the person who's had no contact with dad from long before the time when he went downhill, and the sister who's cared for him ends up with most of the money, if not all of the money, coming in at the son coming in at the last minute. That's a very different kind of circumstance. And they'll try to say she unduly influenced them when there's a very logical reason why it didn't turn out the way that they would have liked.
Right. I don't usually get involved in those cases. A sour grape situation and someone.
Oh, I tell you, there's nothing worse than siblings fighting. The worst divorces are not as bad as siblings fighting. They've got a whole lifetime to build up the anger.
Yep.
Okay, so we're going to drill down into some of the specifics of undue influence. What's an unnatural disposition? What is susceptibility? What's an opportunity? But in this opening section, I thought I'd point out that California passed legislation. Everything Darian said was not from legislation, but from case law that's developed over time. California has a law that the legislature passed, and I'm just going to quickly summarize it. Undue influence means excessive persuasion that causes another person to act or refrain from acting by overcoming that person's free will and results in inequity. I think we're going to have some fireworks on that word. So the factors to consider would be the vulnerability of the victim, the influencer's apparent authority, the actions or tactics used by the influencer, and the equity of the result. I think we need a statute here. I think we need the legislation in our state to get more deeply into what it is and what it isn't, rather than case law developing it. But someone here might disagree with that.
Well, you already know that I disagree. And I will say, for our attendees, you should all go look at this legislation because, and hear me out, I don't think it does anything to advance the law that our case law doesn't currently do. It doesn't cut off or clearly define any of those factors to be considered, and they are already in our law. And in fact, it adds one that we don't currently have, which is this concept of inequity. And so, no, Andrew, there aren't any written materials. Sorry, but we perhaps Michael can send this around later. But what I would say is that the idea of inequity, I think, invites more litigation than we currently have on this issue, because it doesn't get to the unnaturalness of it. It gets to an idea of what's fair, and it's fair according to what. And so I don't like this legislation. I wouldn't like to see it in Massachusetts. But I hear you that maybe some legislation would be useful, but I would like to see it incorporate our established case law on the issue and not introduce new concepts that invite litigation for families that are already sort of going through the turmoil of these types of cases. And I will also just say it's very expensive litigation, right? And so we don't want to generate that.
Just one thing, I will send that material out to everybody later. Another question that came in that really probably can't be done right now, but people are interested if there's any case law. We're talking about how we don't have legislation, but we have case law pointing to this. And if there are any cases I could send out, I would do that as well. So if you want to let me know, I'd be happy to take care of that. Thank you.
Plenty of cases, sure.
Well, plenty of cases. Well, one benefit of having some legislation as opposed to our accumulated law through the case law is to lay out a clearer path for the judge who's going to hear the case. I know I shouldn't say this, but there's an awful lot of judges who don't focus a lot of attention on equity and probate cases, and aren't going to be as up to speed on the nuances of the case law. And it could be helpful as a pathway for them when dealing with the cases to have some kind of statutory guidebook. The trouble we have is that our case law and our application of it is going to have a tremendous amount of discretion, as it would under any statute. But I think there may be, and I think as a result of that, you may get different outcomes depending on the judge and how they perceive things. You're always going to have that in any case, which is why so few cases go to trial in the end. But this may some legislation may help to bring us closer to a center line on some of the dispositions.
Yes, I had one case that went all the way to trial, and it should have been struck right at the beginning.
Mhm.
There was no allegation that held water. So one of my questions here is it better to get these undue influence cases moved to the fiduciary litigation session where the judge is more specialized? I mean, my tendency is to want to do that. Darian, what do you think?
I think it depends on the case, and also the facts of the case and the complexity of that case will determine whether your application would be accepted in the first instance. I guess I wouldn't say, to a one that they belong in the FLS, but the right case, sure.
Mhm.
I mean, the thing, I just want to pause on the legislation, because I just want to say here, while we're being recorded, if we're putting together legislation, I want to be on that committee, because this California, this statute isn't doing it for me.
Yeah. The problem, of course, right now on the issue of the FLS is, unless things have changed in the last week or two, I believe they're in a holding pattern and not accepting any new cases, because the two judges, both of whom have been, are serving as recalls after their, supposed retirements, they are really overwhelmed with numbers, and the judges are very willing, it seems, out in the field to give the cases up to that, session, whether they're the kind that are complex enough that should go there, or like the ones Darian kind of alluded to, where there's no reason why it can't be handled appropriately in a regular session. So, but for the complex cases, that's the place to go, in my opinion.
Okay. All right. So, Tony, what's the minimum that you think should be in an affidavit of objections to survive a motion to strike? I know that's kind of a general question, but
it doesn't get any more. Well, I have to say, you need specificity. Just broad allegations are just never going to cut it. You really need to have facts that can be pointed to, or facts. Obviously, facts are arguable, but you need specific things to get past that initial point, and you need to have enough of them. I mean, it just has to be more than, why would he ever do such a thing? It's crazy.
But what if you need discovery to get those facts?
Well, I find, a lot of the cases that I see now, and when I was on the bench, the attorneys either stipulate to an extension for the period of time to file the statement of objections, or they get a court order extending the time for filing the statement of objections. Because I think you're right. If you're that son in California who's been cut out, it might be hard to get all the things you need to survive that motion to strike or the motion for summary judgment. So I think that's a good point.
Okay. All right. So let's move on to the next segment, which is, what is an unnatural disposition? Is that an inequitable result? Okay, so there's a case. There is a case where a recent person in the scene received most of the estate, and the court ruled that the neighbor who was involved in their lives should have inherited instead. Now, when I think of an unnatural disposition, I think of, your heirs at law. And in fact, there's a law review article written by a BC law professor from '97 that said that's the case law. Unnatural means not in accordance with the heirs at law. So, you got a neighbor, a court ruling that the neighbor it was unnatural not to leave it to the neighbor. How is that not an inequitable result analysis?
Are you talking about Moretti?
I don't remember the name of the case.
So Moretti is the one, I think I'm getting this right. Moretti is the one where there's an elderly man that has, no biological family, not married, no kids. He's got this neighbor and friend who goes on vacation. The man has a stroke or some acute sort of health event, and then requires full-time care. Is that ringing a bell for you?
Yeah, that sounds like the case.
And so what she does is she was working at some health center, and someone that she counseled at the health center was housing insecure. She moves him in, and then this guy takes over the gentleman's life, including his finances, getting him a new lawyer, changing the disposition of his will. And so there, we're not looking at facts where the neighbor is inheriting over family members who are active in the person's life. We're looking at his support system being cut off by a relative stranger to him. And so I would say that is unnatural, because it's unnatural in the course of that person's life and how they had organized their relationships and support system. And so that would be, that's what that means to me. But to your point, it is also inequitable. Not that I think that should be the standard, but it is inequitable because it's this person who has put in a lot of care time, care hours, like emotional capital into this relationship, who was isolated from the elder at the end of his life by this person that she hired to help him.
And I do think that the fact pattern in which the person changes an existing estate plan to a new one versus the person who just has one will, which is allegedly the result of undue influence, are very different cases. I think they're very different cases. And I think in some ways, the fact pattern you described, Darian, is the easier case to parse out than the initial estate plan, which is skewed somehow.
I agree with you. And I also think another really difficult case to parse out is the fact pattern where somebody was in the habit of regularly changing their will. Right. Yeah. So if they're doing it all the time and it's just like flying back and forth, I think that's a harder sort of case to litigate.
Yeah. I think you're right.
I think somebody who doesn't have their own children, their own issue, is more likely to not care about who inherits or to change that. I'm regularly meeting with people who don't know who to leave it to. So those are the people who I think are vulnerable. I don't want to transition to the next section yet, but I think it would be harder to determine what's unnatural for those people.
Brian, didn't you once tell me a story about somebody who said, well, why don't I just leave it to you?
Yeah.
Didn't that come up once in one of our conversations? I thought so. Yeah.
She had CDs that were all reinvesting, and I showed her that she could use the money instead of reinvesting it and go to assisted living, and she was so thrilled she wanted to leave everything to me.
No, the answer is no.
Well, it had to be no, And she said, I can't do that, no way. And it wound up going to charity.
Yeah. Brian, that's not an unusual thing that happens. And in fact, I have an elderly client who has done the same thing. And it's just like, no, we can't do that. Right? Like it violates every ethical rule that I'm bound to follow. Right. And it can be kind of heartbreaking for them because I think that they're trying to give a gift, But I think it's important for us to like remind our fellow practitioners that that's always a no.
Yeah.
Every time.
Just sending her to somebody else to do exactly that is not a good idea.
Just no.
Yeah. So when I said no, she said, "How about if I leave it to your son?" I said,
No.
"Is that okay?" It's like, it's like,
No.
it was a no.
Yeah.
All right. So I think we're in agreement that unnatural can be inequitable, but not necessarily the reverse.
That's what you're saying. Sure.
Okay. All right. Like, I think I worked on her enough. All right. So let's move on to susceptibility, which in the California law is referred to as vulnerability. And I think both of those terms are fairly similar. And let's let Liz weigh in on this.
Yeah, so I mean, in many of the cases that I see, the vulnerability is a result of some type of dementia, Alzheimer's disease, vascular dementia, dementia because of Parkinson's disease, where the individual's memory is impaired, but then also their reasoning becomes impaired as well. Those tend to be the two biggest factors that really impact functioning in a dementia and impact decision making, and then make a person more vulnerable. So as an example, like if you have someone that's kind of moved in and is isolating the elder, then, and if they had a regular Sunday phone call with their cousin or son or niece or whoever, and that phone call stops, if they have memory impairment, they may not realize that that phone call has stopped, or if it stopped, they may not be able to question, like, why haven't I heard from Susan in a couple of weeks? Their memory is impaired. They're not able to recall kind of what their regular routine or who their regular contacts are. And it's a result of this, whoever the perpetrator is, of isolating them and cutting them off from their natural heirs. I mean, similarly, one of the factors I think that can make that even more complicated is that a lot of folks that I see also have a significant hearing impairment. And so it's hard for them to talk on the phone or to be able to have a conversation on the phone. They may, just not have a lot of phone conversations in that regard. So that also makes it easier for them to be isolated. So it's a combination of factors in terms of impaired memory, impaired reasoning, impaired judgment, that they can't question and recall their regular relationships, their regular routine, even if they had a previous estate plan, or who their attorney might be, or who they might have, who might have been named in their estate plan previously. That makes that person really, like, it's a ripe situation for someone to come in and start to influence them to go in a particular direction. I mean, I was involved in a case where an elderly woman was very close with a niece, but the niece didn't live nearby, but they did communicate regularly. The niece lived like in Florida, and the elder was up here. But they would always see them when they traveled through, or tried to have conversations. This elder's hearing became impaired, and she became increasingly demented, not completely incapacitated, but certainly there was an element of a dementia there. And then another individual kind of came in who claimed to be a longtime friend, but it wasn't clear that this person ever actually knew them, but kind of preyed on their giving personality, this woman's giving personality and her friendliness, and gradually led this woman to believe that this new person that came into her life was a longtime friend. And the estate had been changed a couple of times. So to your point, Darian, it wasn't completely unusual for the estate to be changed, but it was changed significantly so that at the end, the niece, who had been initially named to be the primary heir, was not cut out of the will, but was left like $10,000, where she was supposed to have been given, well into the six figures and inheriting property. So that was a case where it was a combination of a dementia, a hearing impairment, and isolation that made this particular woman like extremely vulnerable for someone else to come in and exert their influence on them and their wishes.
Is there a particular lobe of the brain that you'd be concerned about, like executive functioning?
Well, that's the frontal lobe.
That's the frontal lobe.
That's executive functioning. Yeah, I mean, it tends to be a little bit more diffuse. I mean, memories in the executive function, the memories is also partly frontal lobe. The hippocampus is part of memory. So, you know, the specifics of the diagnosis aren't necessarily that important. It more so the, you know, the nature of the impairment. So in terms of vulnerability, just when I come in typically later in the case after it's already happened. And so trying to go back in time to figure out when this might have started. That's one of the challenges. And one of the challenges, I think, as Tony said, in like proving it, because you can't really always say when the person actually became vulnerable, because you're seeing them often much later after it happened.
So the frontal lobe doesn't develop really until you're what, 25 completely? Am I incorrect on that?
Yeah, I mean, yeah, that's what we always talk about. We go easy on the teenagers because their frontal lobes aren't.
Yeah, so someone could inherit at age 18 as an adult in Massachusetts, and we could have an undue influence case for those well, let's say you have a drug addict parent who, you know, just makes the kid make the money joint and then uses the money.
True.
So it's possible to go undue influence there too.
Yes, I mean, that's I tend to be more on the other end of the age spectrum, but absolutely, yes. You know, I think that would also be, I don't know if that would be an easier or harder case to prove if it's a, you know, especially if the 18-year-old is living with the parent.
Yeah. I'll tell you though, it's funny you say that fact pattern. It's not undue influence specifically, but boy, the number of cases that I have seen and continue to see with convenience additions to bank accounts not being a gift or being a gift. Boy, I'll tell you, it seems, you swear it comes up on every single case or many cases.
Well, Judge, do you think that that's because people are trying to do workarounds, work around the probate process, and so they end up actually generating litigation about these decisions? Yeah.
Absolutely. That's part of it. I mean, it's very often it's just you know, it's meant to be a convenience account, I think, and I wouldn't try to put a percentage that I see one way.
Nope, I think he froze.
Well, I'll help him. I think it's 90-10.
Judge Nesi, your voice dropped. Can you hear me? Everybody else there?
Yeah, he dropped out.
Oh, I think maybe his headphones died.
Okay. Well, I was just going to ask him whether we need an expert in a case like this.
Well, yeah.
What do you think, Darian? Well,
I'm going to give you the answer I always give. Depends on the case. I think, you know, like, when would I call Liz? Well, she knows the answer to this. I will call Liz when I think that there is some aspect to the undue influence, the vulnerability of the person who's been influenced that has to do with their cognition. And if I want an expert to opine by a post hoc review of that person's medical records and doctor's notes, you know, and maybe if she's willing to do it or thinks that there's value in interviewing sort of collateral folks who are involved in their life, then that would be the time I would call somebody like Liz to talk about that. And I think that some of these alternative fact patterns that we could come up with are sort of harder to prove, like, you know, your 18-year-old living with a parent with a convenience account. I mean, I guess, you know, maybe we would find some expert in young developing brains, and perhaps that would be an appropriate expert for something like that. There's another type of fact pattern that I'm really interested in, and in particular, I'd love to know if Judge Nesi and I guess Liz, you wouldn't have seen this, but the patterns that deal with someone who has good cognition, but is just physically frail, or, you know, has some sort of dependency on drugs or alcohol, or, you know, has chronic anxiety or depression. Those are the cases that I think are particularly juicy, and I would love to hear more about your experiences with them.
Well, excuse me when
Pretty
your bug died, by the way.
Did you hear my joke? I made a joke for you.
No, I missed it. Sorry.
When you said you weren't going to give percentages of the convenience accounts, I said 90-10.
90-10, which way? They're 90% convenience or 90% estate planning?
Not 90% convenience.
Yeah, I would say that that's exactly right. I'd say they're much more likely to be for convenience. And anyway, as to that, I can't say that I can think of many examples that fit what you've just described, but could I see the circumstance as being one that would raise questions and possibly be a situation where the undue influence could be exerted? Sure, I definitely see that. I can't think of examples from my head, but the physical frailty very often goes along with the hospitalization or the isolation of the person. And often that goes along with the quick change of the estate plan with a new lawyer that the relative brings in that has never met the person before. So anyway.
It could be legal Zoom.
But for some of those alternative fact patterns, would you be looking for a particular type of expert or expert testimony in general about the effect of a frailty or the effect of diagnoses, the effect of an addiction, things like that?
It certainly couldn't hurt. I've seen plenty of people been able to prove undue influence without an expert opinion or medical opinion coming in. However, when you're really talking about the diminished capacity that creates the opportunity, I think it really is helpful. No question about that.
Yeah,
for somebody to parse through properly the medical records and tell us what they really mean.
Right. I think that the isolation piece is key, both in the physical frailty, but also in the depression or in the anxiety, if it's preventing someone from leaving their home. Not so much the physical frailty, but both a significant depression and a significant anxiety can also impact cognitive functioning, can impact memory. It's what we used to call like a pseudo dementia, that they're presenting as more confused, but it's because they're depressed or anxious. And then when they're no longer depressed or anxious, they're presenting as mentally clear. So, I haven't seen cases where it was purely depression or purely anxiety. But I think the thing that all of those have in common is the isolation piece, and then the opportunity for a person to come in and exert their influence.
I think we had a question from somebody asking about what the SJC has said about the necessity of expert testimony. I don't recall a case that specifically says that you have to have expert testimony.
No,
neither do I.
Okay, so we've pretty much covered the next segment, which is when do you have an opportunity? And we've talked a bit about isolation and choosing professionals. Anybody have anything to add to that?
Well, I think, there's three different, if you're dealing with an elder with some type of dementia, that you could be calling a neuropsychologist, a psychiatrist, or a neurologist. Any one of those three would be offering a slightly different perspective. So I think if it's a person and then you also have to be thinking about, like, is this a postmortem case, or is the victim still alive? But each one of those individuals is going to bring a different perspective and be able to to offer something different in terms of their expertise. So the psychiatrist, if you have a case where it's someone who is more purely mentally ill, like a schizophrenia or depression, then without a cognitive component, the psychiatrist may be the best person to do that. If there is more of a cognitive piece, and particularly if the individual is still alive, then the neuropsychologist, I think, is probably the best way to go, mainly because a neuropsych eval offers a lot of objective information and objective, data and scoring and performance and norms based on age. And the neurologist may be the best if you're looking at more of a combination of both some physical impairment caused and cognitive impairment, but that's caused by a neurological illness like a Parkinson's situation. So I think the specifics of the case may dictate which direction you want to go as far as which expert you want to have.
Okay, well, this is not even in the outline, or it's out of order, but let me just follow up with, I have somebody that I'm doing something for who's on their deathbed. I don't have time to call you. How do I preserve the evidence that's needed? I have a checklist that I've gotten from many mental status exams, but what can we do? What kinds of questions should we be asking to try to preserve whatever evidence that we can gather at that time?
So hopefully, Brian, if you're at their deathbed, it's not the first time you've met with the person. And that would be, the biggest tip that, I would give someone in your situation, that hopefully you've met this person before, you've met them alone, you have a good sense of what their estate looks like, and that they know what their estate entails, and that you have a good sense of what their relationships are with the people who will inherit, right? And then the other thing that I've been discussing with some of our brothers and sisters is this idea about recording the signings when we're uncertain about whether there's going to be litigation that follows, or if we think there will be litigation that follows, and recording that signing where you're going through the document and the person is telling you what the disposition is, what the estate looks like, and you can have a visual representation of the state at that signing. And then the other thing I would say is I hope your file notes are really immaculate, because your file is going to be really important evidence in later litigation for your understanding of that person's capacity and what they shared with you.
I have to say, in following up on what you just said, Darian, I remember a trial I had where they took that precaution of recording the signing, and the lawyer did a great job in getting the person to articulate exactly what was going on. And I'll tell you, it made the rest of the evidence people had, pale in comparison. It was just so well done. Of course, having the person say yes or no to questions is not getting you anywhere when you do the videotape. They have to articulate. Right. And of course, if you're in a deathbed situation, certainly that's not first of all, it's not easy to organize. But it's in the case of someone where you think there might be litigation in the future, I don't see the downside of it if you're comfortable with what you're recording.
I think the why is important, like why if they're making a change in particular, who are the players? If they're making a change, why is this person no longer benefiting, and have that recorded so that you can see that it's their own words and and giving you an explanation. I mean, I think the trick comes in is that, like, I was involved in a case where there was a recording and there was isolation, and the why was because I don't see that person anymore, but they weren't seeing that person anymore because they were being isolated. So that, so they were able to give an explanation. So I don't know if that was helpful or not.
May not have helped in that case, yeah.
Right, the why was part of the undue influence. So,
but I would argue that is helpful in getting to the truth, right? Yeah. If you have a recording of somebody, irrespective of our advocacy positions, if you have a recording of somebody and they don't know, why, or they don't know what they're doing, and it's recorded and we have it, then we can have some confidence that we're getting to the right result, even if it's maybe not the result that our particular client wants. And I know it's terrible to say, but I don't see there being a downside to having a recording if what you're doing is on the up and up, right? It's only bad for you if you're doing something shady.
Here's a question that just occurs to me. What's your obligation if you end up in litigation for disclosing the fact that the recording exists if nobody asks specifically that question? Let's assume you do the recording
Yeah.
and it doesn't go well, and the tape still exists or the recording still exists, what's your obligation with regard to that when it comes to litigation? I don't know. I don't know that we have to find
What's
the
your
answer here
what's your
today.
obligation when you know it didn't go well? Should you ask the client, can I delete this right now?
No, but if it doesn't go well, Brian, wouldn't it be your obligation to pause and say, does this person really understand what we're doing, and can we go forward with the signing?
Right.
Yeah.
Right.
I think the lawyer has to be careful.
This is it's part of our outline. I'm just going to skip ahead to it. Comment 6 to the Mass Rules of Professional Conduct. Rule 1:14 says you have to consider and balance the ability of the client to articulate reasoning leading to a decision and the substantive fairness of the decision. So we shouldn't just be doing what the client wants. We should be finding out why they want to do it, because if we can get a why, if there's reasoning, then we can help sustain what they want. It won't get tossed out as being inequitable or
Fix it.
or unnatural. Okay. All right. So, and there was a case back in '93, Lugathetti versus Gordon, that said that attorney owes to the client. You got to reasonably believe that the person's competent and free from undue influence before you do something, because that's part of your undivided loyalty to the client. So I think we have a duty to find this out before we execute documents. Tony, anything to add on that?
I don't disagree. I'm not going to comment on what the lawyer's duty is, but it makes certainly good sense to me. It's just amazing to me the number of times I have seen the family member who's going to benefit making the arrangements with a new lawyer who the person has never met before, and getting a will drafted with not even a first draft reviewed with the client, and then presented to the person in the hospital. I mean, it amazes me how often it occurs. And if there was ever a fact pattern that raises every red flag, it's just what were the steps that led up to that person signing that will. And I'll tell you that lawyer has an awful lot of explaining to do as to why this was a legitimate step that they took in getting that estate plan signed, because it's just a big, huge red flag when that new lawyer comes in who hasn't met with the client, doesn't know all those lists of things that Darian just went over, or even half of them, or even 10% of them.
Well,
people do it.
Doesn't a lawyer have a duty to meet alone with the client early?
I can't,
as a matter of practice, we tell the children who make the appointment, we're going to meet with the parent alone. And we lose a lot of clients that way because they'll just shop. They'll go to some lawyer who let them be in the room and do all the talking.
Yeah. No, I just, again, if they're in the room, a red flag, big red flag jumps up, especially if it's an elder who has any history of a decline that influences, that the influence might have been exerted based on it. So I agree with your practice, Brian. I'm amazed when it's not done, but it's amazing how often it does happen, though, that they're in the room, they made the arrangements, they're in the room, and they're getting the benefit.
Those are the cases that I see.
Yeah.
So that's one rule we want to submit to all the lawyers listening. Meet alone with your client.
Yeah.
Don't the children. I mean, how would you ever ferret out undue influence if you didn't meet alone with the client? The child is going to do a lot of the talking at the meeting if you let the child come into the meeting, and the parent who's relying on the child is going to let the child talk. Yeah. All right. So
just their presence, even if just the fact of the presence of the child in the meeting, in the room, I think is where the problem really starts. Never mind who's talking in the room, because, you know, if they are concerned and they're susceptible and know that they're going to catch hell later if they don't say all the right stuff, I think having the child in the room is just bad. So.
There's another reason why it's important to meet with someone more than one time too, because you want to get a sense that their desires aren't changing based on time of day, who's around, who brings them, right? You want to just get a general sense that, like, this is really what you want, okay? And tell me about it again and why, and put that in your notes.
but the true undue influencers are not going to let you have a chance to do that, right? They're going to, you know, they're going to take the parent somewhere else.
That's true. And then, you know, to get back to 1.14, Brian, there's a question then about if your flag is really raised that there's somebody trying to do something bad, you know, do we have a responsibility to do something for a prospective client who doesn't actually end up becoming a client? And I think that that's a real gray area. Although I can tell you offline that we have a Mass NAILA colleague who did report an elder abuse. So we're not without we're not without resources to address if we think that there's real harm to be being done.
Well, one of the things for lawyers to consider if they really want, you know, the practice of law is a profession, but it's also a business. And if they don't want to lose the client and they let the child into the room, they might wind up testifying for free for a long time and have a lot of unbillable time out there after explaining what happened. So it may not be worth it. So to go over probably the last thing is the burden of proof can be shifted in some of these cases. There are 3 cases, Cleary, Moretti, and Rempelakis, that read together say that if you have a power of attorney that you're using and you're involved in all aspects of the transaction is not necessarily an estate plan. It could be a transfer of assets. It could be a below market sale, and you're benefiting personally, then the burden of proof can be shifted to you to prove what happened. So how much proof do you need on that, Tony, when you see that?
I don't know that I can give an answer that'll be thoughtful, to be honest with you. I've thought about it before. I've seen circumstances where, you know, the burden has had to shift over because of the power of attorney, but where the power of attorney is central to what's going on, and not just the fact that it's out there and exists. I don't think the fact that a power of attorney exists automatically shifts the burden. And maybe that was a case you and I had, Brian, way back when, if I recall. I think the power of attorney has to be somewhat implicated in what's being done for it to really be the burden shift. You know, I see just as often people who are trustees, and if there was ever a clear case, I think it's more with the trustee than with the power of attorney. But that's just my view, and I can't say I've spent a lot of time researching it. I'd love to hear what you folks think about it.
And this is what you just said is part of my argument that we need legislation. Maybe not exactly the California legislation, but this judge-made rule says you have to use a power of attorney or else we won't shift the burden. So what if the person that sold their home and everything they have is made joint with the undue influencer. There's no need for a power of attorney in that situation. And they're taking advantage of the situation, using the money for themselves. We can't shift that burden. Well, that's what the case law has developed into saying you can't shift in that situation. But given that situation, if the appeals court saw that, maybe they would change the rule. That's why I think we need a legislative body to look at the big picture.
Or a case.
Yes, right. I mean, both are compelling avenues to get to the same gap. And I hear you that there are other ways other than using a durable power of attorney to exercise control over someone's assets and to benefit yourself. But there are also equitable claims that are available to litigants that aren't undue influence. You can do unjust enrichment. You can do an intentional interference with inheritance. There are other ways to get to the same result until we have a case that tees it up for the SJC or the appeals court to give us a really good decision we can cite to.
But I think the legislature can look at the bigger picture. So let me give you an example. I say to my mother, hey, I have one kid. My son doesn't have a child. My daughter does, my sister doesn't have a child. There are three of us. She has 3 issues. Why don't you split it 3 ways instead of 2 ways? Now, that's not undue influence because I just suggested it. If I say it every day, and then maybe it gets to the point where I'm being very pushy, but I didn't benefit. I'm getting less now. Is that undue influence?
Well, does your sister know?
No, I'm not going to let her know about this.
This is being recorded, Brian.
My brother already died. It's too late for me to pull this.
I think that the focus in that fact pattern is going to be what would your mother have done otherwise if she was exercising her own free will?
Right, but we can't shift the burden here, right? I didn't benefit.
No, you can't.
I think so. No.
So what is this thing? So
are you giving people ideas on how to circumvent the case law in order to get unnatural dispositions without the burden shifting?
Yes. The subtitle of this program was How to Commit Undue Influence. And then finally, so maybe one last thing, fee awards after trial. I mean, there's a possibility after a trial.
Totally.
You know, I mean, I would assume it's more likely after there's been burden shifting that there'd be an award, but
not necessarily, because it only has to be, so if we're going to use chapter 215, section 45, it only has to be a contested case and that the court just determines whether justice and equity require the fees to be shifted. So it's a squishy standard. It's available in a contested, what? Why are you shaking your head?
No. I'm shaking my head because it's just so subjective on the part of the judges.
Totally.
50 probate judges, 50 opinions on that.
Yeah, but it's available.
A place. Yeah.
Well, it's technically available.
Right. I have more people. Yeah.
I've gotten it.
Yeah.
Okay.
Since I've retired, I've had more people complain to me about my way of awarding fees or not awarding fees when I was on the bench. When I'm with lawyers doing conciliations now, they all want to let me know what they thought about how I did or didn't give fees. So.
Yeah, but I will just say that I like that it's squishy because I think in the same way that I like that the case law is squishy, it allows you to make arguments that fit your facts and to be persuasive about those arguments. And so if you have a case where you had some person coming out of nowhere saying, oh, there's been undue influence, they had nothing, you couldn't get it out on the motion to strike, and you end up spending a lot of money at the end of that case, when the evidence was fairly clear that there was no undue influence, you could say to the judge, hey, Judge Nesi, this like whack-a-mole spent all this money and we had to spend money out of the estate doing this and we want them to pay it back.
Yep.
I think that's lovely. So I'm all for the squish.
Okay, that's a
One
good
thing-
closing line.
And if I could have one closing line,
Of course.
be cautious about inserting interim clauses. Because they can cut both ways. They can cut both ways for you, even though now they're recognized. I've seen funny outcomes with interim clauses. That's my closing comment.
Uh-oh.
Okay,
All right. Well,
I think we hit our time.
Yep,
Is that the beep? that ends-
perfect.
Okay.
Well, thank you.
Well, thank you all.
Yep. Thank you all so much for participating. It was really fun and interesting. And it was great to have you all here. And I hope to see you all again soon and have a great holiday.
Oh, thanks. I had a blast.
Thank you.
We'll talk to you soon.
Comments
Care.
and to everyone
Ta-
else. Thank
Take
you.
care, everybody.
Bye.
Bye.
Okay.
Bye.
Bye.